On the criminal petition for listing, my lord. Criminal petition for listing, day after tomorrow. Temporary.
$33. Yes. You are for petitioner on the prayer of Mr. Norman Larnik, counsel for the petitioner. List the case on a date in the first week of January 2026.
Lordship, I beg to mention listing of a criminal review petition on Wednesday, Lordship.
Criminal?
Criminal revision petition, Lordship, on Wednesday, Lordship.
Motion.
May I please, Your Lordship? Your Lordship, beg to mention listing of a criminal petition on Wednesday for motion, Your Lordship.
Item number 2. Yes. Okay, on the prayer of Mr. N. Learned counsel for the petitioner. Case is passed over for the day.
Yeah, please, Your Lordship. Also, back to mention item number 4, Lordship. Also, as per our information, Lordship, search sheet has been filed, Lordship. So we are waiting for the instruction whether to quash the search sheet also or not, Lordship. So we need some time, Lordship, after vacation, Lordship.
So if search sheet has been filed, then no point. You have to challenge both.
Yes, Lordship, either we will amend the petition or let's say another petition we will file, then we will take the vote. Lordship.
On the prayer of Mr.
A Mena, Lordship.
A. Mena, learned counsel for the petitioner. Please the case on a date in the month of January.
Lordship, also another prayer, Lordship, for item number 5, Lordship. Lordship, this matter may come up after vacation, Lordship.
Same.
I criminal lordship in connection with criminal appeal, Your Lordship. That day after tomorrow, Your Lordship, 17th of December, Lordship.
Day after tomorrow.
Obliged, Lordship.
My Lordship, I beg to mention for listing an IA criminal filed in criminal revision petition that may be listed on Wednesday.
Lordship, I beg to make a mention for item number 13 of the daily list. Lordship, may kindly take up this matter after Bihu vacation, Your Lordship.
After Bihu vacation 2026.
29th, Your Lordship, if convenient.
Okay.
It's a hearing matter.
The option naam kita kun kuta ase. You are for
Petitioner, NN.
Mr. N. Dotto, petitioner.
I'm for the respondents, Your Honor.
Didas. Didas for
Respondent number 2 and 3.
2 and 3. Your standing counsel,
Yes.
CCI. CCI 2 and 3. Mr. B. Chaudhary. Respondent number
4.
4. Okay. On the joint prayer of the learned counsel for the parties, list the case on 29.
Deeply obliged.
Obliged.
1.
May I please, Your Lordship? Item number 8, ma'am.
8.
The matter may be after vacation, my lord.
Okay, on the prayer of Miss,
Mr. I.S. Loskar.
on a prayer made on behalf of Mr. I.S. Loskar, learned counsel for the petitioners, place the case on a date after the ensuing winter vacation.
May I please, Your Lordship? Lordship, with regard to item number 21, on the last occasion, the CD was called for, Lordship. However, it has not been received.
Yes, madam.
Therefore, Lordship, this matter may be listed after vacation.
CD received.
Did not receive, Lordship.
Okay, Mr.
N.R. Sharma, Lordship.
N.R. Sharma, learned counsel for the petitioner is present. Miss A. Begum, learned edition. Public prosecutor for the respondent number 1 state has submitted that the case that comma as called for has not yet been received. First of as sought for and agreed to by the learned counsel for the parties, list the case on a date. When?
Lordship, after the winter break, any date may be fixed in January.
Okay. 19th?
Lordship.
19th of January.
May I please,
Obliged.
Lordship? Lordship, I beg to mention one criminal petition on Wednesday.
New matter
No, Lordship.
after vacation time.
May I please, Your Lordship? I beg to mention for listing a new motion matter, my lord.
New question.
prior to 18.
Wednesday,
Lordship.
filed
Already
or
filed.
yet to be filed?
12. Filed on 12.
Your Lordship, I beg to mention an IA for condemnation of delay. It's related to a criminal revision petition, Your Lordship.
Okay,
This week,
when?
16th, 17th, Your Lordship. Day after.
Yep.
Oblige, Your Lordship.
Daily list for motion, item number 1.
May I plead the lordship?
Yes.
This is a criminal revision petition against impung order dated 25/1/2025, passed by the learned council, passed by the CGM Kamrupam, where the petition for a Zimma of a vehicle and a land document, your lordship. The petition was rejected by the CGM.
Where is the order?
Impung order dated 25 page number, your lordship.
Today's,
19. your lordship.
Lordship.
submitted, unable to produce. Repurchase of the. Yes, this motorcycle is kept at the police station.
Lordship.
When it was seized.
It was seized on Twenty-one to
Two-
2023.
2023.
Since 23, it was.
What is the offense? 457,380. Madam, full justification on the next date from the IO.
Lordship, I'll get a report from it, Lordship.
Justification for 2.5 years.
Lordship.
Heard, Miss
It's Z Daisy.
Learned Counsel for the petitioner. And Ms. A. Begum, learned additional public prosecutor for the respondent state. First, this criminal petition is referred to a sale and order dated 24/1/2025, passed by the Court of Learned Chief Judicial Magistrate Kamrup Metro in connection with PR case number 1732/2024. First off, the petition referred an application seeking custody of a motorcycle bearing registration number 1AS-15/V-2500, owned by him, which was seized in connection with Lotta Hill Police Station case number 57/2022, registered for offences under section 457/380 IPC by way of a seizure memo dated 21/2/2023. First off, from the impugn order dated 24/1/2023, it is noticed that the seized motorcycle has been kept in the police station campus, within the premises of the police station. First off, the prayer for custody was rejected on the ground that the seized motorcycle was purchased by the accused out of the stolen money. Post of issue notice returnable 21/1/2026. As Ms. Begum has appeared in accepted notice on behalf of the respondent, sole respondent state. Issuance of formal notice is dispensed with. Learned additional public prosecutor shall produce a report as regards necessity of keeping the seized motorcycle in custody along with justification
Your Lordship,
on the next date of listing.
Your Lordship, one non-judicial stamp paper also seized by the police, Your Lordship. This one is the seized.
The custody application was also preferred, seeking release of there is nothing in the impugned order. Where is your application?
Seizure list, Your Lordship.
Huh? For seizure is another thing. Where is your application for custody? Did you ask for it?
Yes, I asked for it also.
Where is it? There is no reflection in the order.
In the petition, it was there.
We don't know of the petition. What is there in the petition? We only know the order. Bring the application on record, then we'll decide. Otherwise, that order is silent.
Next date is
I see, na? Iman kolo.
God bless Your Lordship.
Item 3.
Wait, legal lord.
Lord, in this present case, my lord, there are two cases, my lord. The petitioner had an altercation and.
What is a prayer here? Which one? What is a,
My lordship,
what is a prayer first?
there my lordship will find it page number.
Resist the please to admit the
15.
present revision petition. Call for the record, we should notice opposite party to provide impugned judgment. Criminal appeal. Arising out of. Passed by the parents of, should not be citizen passed out. May be pleased to set aside and quash the. What is the judicial magistrate order?
That page 75, my lord. The relevant.
What is the sentence?
Sentence, my lord, 1 month imprisonment and 1,000 rupees fine.
Hmm.
Para 40, page 75.
Hmm.
Para 40 it starts, my lord.
Then appellate court,
Appellate court, my lord,
conviction 323
Page-
34.
page 96, my lord. Page 96,
Then allowed partially. Partially allowed.
partially allowed. my lord.
So you are aggrieved.
I'm agree,
By what? Reduction of the sentence.
my lordship, because my lord, there is no reason as to why, because there are two cases. In one case, if my lordship may kindly come to page number 110. The
But those are cross cases.
cross cases. my lord. 1:5, my lord. I assaulted 5%, 5.
Oh, that we are not going to. We are into the trial court judgment and appellate court judgment.
Appellate court.
That
Appellate
is,
court,
you,
I prefer the petition.
you seek enhancement of judge.
Yes,
sentence.
372 I filed, my lord.
What has been
That-
removed? 1 month.
That my lordship will find.
1 month has been removed.
Remove, my lord. I filed, my lord, on. On 11/8/2025, I filed an appeal. under
Whether in
Section
revision
372.
enhancement can, is possible.
That is why my prayer, my lord, because both the cases needs to be taken up together, my lord, as it is a cross case. And if my lordship may kindly see, the next page, my lord, filing that 11/8/2025.
Well, you should notice at this stage, heard Mr. M.K. Das singing enhancement.
My lordship,
That is your prayer only.
my lordship.
M.K. Das, learned counsel for the revision petitioner. And Mr. M.P. Goswami, learned additional public prosecutor for the respondent number 1, State of Assam. Post office. In an affair lodged by the petitioner, which was registered as, an affair lodged by the petitioner was registered as Rongapara, GRPS,
GRPS. ma'am.
case number 08/2022. Full stop. Within bracket. Within bracket, nalage, comma, with corresponding GR case number 539/2022 and PRC number 41/2023. Full stop. In the trial of PRC number 41/2023, comma, the respondent number 226. 5 accused.
5 accused. ma'am.
226. Were charge seated and they stood in the trial after full stop, after trial, comma. The court of Judicial Magistrate First Class Udalguri, within bracket trial court, convicted the accused persons for the offense under section 323 IPC, read with section 34 IPC, and they were sentenced to undergo simple imprisonment for 1 month and to pay a fine of rupees 1,000 each with default stipulation. Full stop. On appeal, however, the appellate court of the session judge Udalguri
Udalguri.
partially allowed the appeal preferred by the accused persons and by judgment. An order dated 12/8/2025, comma, the appellate court has only imposed a fine of rupees 1,000 each. The appellate court, comma, modifying the sentence, comma, sentence the accused persons to pay a fine of rupees 1,000 each with a default stipulation. Full stop. Agreed by the judgment and order of the appellate court. The petition has preferred the Assistant Criminal Revision petition. Issue notice returnable for weeks as Goswami, as per number 1. Steps 2 to 6 by speed post as well as by usual mode within 7 working days from today.
Deeply appraised.
Item number 6.
Please, your lordship. Zimma petition, your lordship. Lordship, the accused, the petitioner is not the accused person, your lordship. She is the lady, your lordship.
Ah.
And the
What is
accused
the stage of the
charge sheet submitted, your lordship. Already investigation has been completed.
scan copy received?
Yes.
Scan copy received?
Scan copy, yes, madam, in motion, madam, the receipt, madam.
Received. Okay. We'll put it, we'll issue notice,
Yes.
making it 5th of January. We'll
Yes.
decide.
Lordship, the petitioner is the real owner, your lordship. And only on
All right, we have to hear it. We have to examine the scan copy.
scan copy already received, your.
Right. Heard, miss?
A Medhi.
A. Medhi, learned counsel for the petition, and Mr. M. P. Goswami, learned additional public prosecutor for the respondent state. Full stop. The scanned copy of the records of NDPS case number,
DPS case number, my lord.
104/25.
where it is mentioned.
Actually, your lordship, before the search, it has been filed. So,
That's the reason, nahi?
I have had
Yes.
the search sheet copy, your lordship, through the additional affidavit.
Okay.
An IA has been filed, my lord. There it is. IA has been filed.
I hate case.
Yes, through the additional affidavit.
Additional affidavit.
Yes, lord.
Additional
Okay.
affidavit.
Okay.
Page number
Uh,
24.
This case number 104 of 2025. Have been received. Post of issue notice returnable on 6th of February 2000, January 2025. On endeavor will be made for final consideration of the criminal petition on 6/1/2025. Will decide on that day.
Item number 7.
My lord, in this case, notice has already been issued on my lord.
Notice issued.
And scan copy of PCR was called for, that is not received.
Okay. What is the issue?
Issue, my lord, quashing of entire proceeding, my lord, and there was
Okay.
two orders, my lord.
Heard Mr. Ekvedas, learned counsel for the petitioner, and Mr. M. P. Goswami, learned additional public prosecutor for the respondent state. Full stop. The scanned copies of the TCR in connection with GR case number 8824/2016 was called for
Okay.
by the previous order dated 24/11/2025. Full stop. As per office note dated 11/12/2025, comma. The TCR has not yet been received. Full stop. Lays the case on after review.
My lord, the exit is fixed, my lord, on the trial court, my lord.
Can't help it, sir.
21st January.
21. Issue a reminder for the TCL. Huh? Can copy of the TCL.
Item 9.
Huh.
Here the order of cognizance is put to challenge, man.
Hmm?
Order of cognizance has been challenged in this petition.
Instant petition is preferred by the science assailing legality of the proceedings instituted against the petition. Who is the complaint?
That's right.
Complaint, my lord, will find at page 17 onwards, my lord. No, my lord,
You are accused number 1.
my lord, the other cognizance has not been taken against the other accused person.
Okay. This is the complaint. Then
Complaint, my lord.
what are the order sheets? Let us see the order sheets.
My lord. Page 25 onwards, my lord.
CR is received on transfer for disposal. Put up before me as time wasted is an attorney general, CG.
Like
Here put complaint is absent. Okay,
here, here.
I'll
my lord.
come to, I'll hear you.
I'm.
Transfer to E. Begum. January, March. Absent with tips allowed. Which is the impugn order?
Impugn order, my lord, will find at page 42.
What is 28?
28, lordship may kindly see.
28.
28, my lord.
Page
And
20.
it is issued before taking cognizance.
Yes,
I'm sorry,
page 28.
28, yes. Notice was issued to the accused. Now, my lord, the 223 says
How? What does it say?
After complaint being filed, the magistrate has to take the verification statement of the complainant or not or my lord, and the witnesses if any. That has not been done, my lord.
Ah,
Prior earlier CRPC it was 200, my lord.
No, it's my convenience, fine.
who is 6-8 order?
68842, my lord. That is the
Huh?
order of
Is 42.
68. That is the order of cognizance, no? Complainant is required to be examined, my lord. And also the witnesses. Thereafter,
Notice to the
notice to
sense,
the
so.
accused.
What is page 30?
30 is the petition filed by the accused, my lord, on the point of cognizance.
30.
Page 30.
Okay. Did you take up that plea?
That was not taken, my lord, in the
7 accused person. Showing court. Yes, Mr. Usman.
In page 42, my lord, it is the prayer is allowed regarding the status of the accused, my lord. Thereafter, again, the notice cognizance taken. Page 42, your lordship, may kindly say.
6/8/2025.
Yes, my lord. Here, first, my lord,
So where is the examination of the complainant?
that is not there, my lord. Because on 42, my lord, it says accused is absent, showing cause.
Any other ground?
Prayer is allowed.
we have, my lord, 418, my lord,
Sitting is not made up.
not made, what?
Heard, Mr. P.K. Munir, learned counsel for the petitioner, and Mr. M.P. Gusami,
Yes.
learned additional public prosecutor for the respondent number.
Respond number, do you know?
Two, my lord, one.
State is 1, my lord.
1,
1.
State of Assam. Full stop. This petition under section 4528, comma B and SS is preferred, seeking quashing of the proceedings of a complaint case, comma CR 31/2025, comma presently pending in the Court of Learned Judicial Magistrate First Class, Tinsukia, and also to assail an order dated 6/8/2025 trial court passed by the trial court, whereby the learned trial court has issued process against the petitioner for her appearance to stand in the trial of the said complaint case. Full stop. Where Mr. Munir, learned counsel for the petitioner, has submitted that before, while taking cognizance, while taking cognizance by the order dated 6/8/2025, the learned trial court did not adhere to the provisions of section 223
Two to
B
three.
and SS as the complainant and stroke or his witnesses were not examined and the trial court up on receipt of a complaint had straightaway issued summons to the petitioner who was arraigned as accused number 1 in the complaint.
Notice for pre-cognizance hearing was also issued.
For pre-cognizance hearing. First of all, he has further submitted that the contents of the complaint do not reveal commission of any offense under section 318 B and S. First of all, issue notice returnable 4 weeks. As Mr. Goswami, respondent
Yes.
1. No formal notice. The petitioner shall take steps for service of notice from the respondent number 2 that's complaining by speed post as well as by usual process within 7 working days from today. First of having a regard to the provisions of section 223 B and SS and the and after having perused the orders, dated 8/5/2025, and the subsequent orders up to 6/8/2025 passed by the learned trial court, it primarily appears that the learned trial court had proceeded to issue notice to the petitioner for appearance for the purpose of pre-cognizance hearing without examining the complainant and stroke or his witnesses. First of, it is it is ordered, in the item that the further proceedings of complaint case number so pending before the court of so shall remain suspended till the returnable date.
Item number 10.
May it please the Lord. Lord, I have come against Lord the FIR vis-a-vis the charge sheet and the order of taking cognizance. My case is, my lord, that in the FIR as well as charge sheet, my lord. Clearly, my lord, a case under section 420 doesn't make out.
420,
my lord.
okay.
420.
Where is the FIR?
FIR, my lord, you will find at page 20. 20 is the Assamese vernacular, my lord.
Assamese.
Married.
Who is Azharkari? Ankur Sharma.
My lordship.
Indonesian Kuldeep Boishoy. Hemadi Satin Microfinance Bank. কর্মচারী কাম কৰি থাকোঁতে মই তেওঁৰ লগত চিনাকি হওঁ। পিছত গুৱাহাটী নাবাদ কাৰ্যালয়ত চাকৰি কৰোঁ বুলি মোৰ আপোনাৰ কথা পাতি থাকে। তেওঁ মোৰ নাবাদৰ পৰা কিলাক লোন উলিয়াই দিম বুলি কয়। মই লোন ল'ম বুলি কওঁ। তেওঁ হাজাত মই ইংৰাজীত থাকে। Stone sanction মলে পঠিয়াই দিয়ে তেতিয়া মই দিয়া বেংকত একাউণ্টলৈ যোৱা আগষ্ট 4 1 লাখ জমা কৰোঁ যোৱা ছেপ্টেম্বৰ মাহত Komal Barmano, counted for that.
And my lord, in a
Money was deposited in your account.
my lordship. But there is nothing that I induced him to, my lord, deposit.
Who
any
issued
money.
a loan sanction letter?
20, that has been, my lord, seized, page 24, my lord. And it is not a case of 468 also, that this letter is, my lord, forced.
Page?
Page 24, my lord. List of articles, material objects relied upon. Then, my lord, 7 copies of bank statement of Ankur Sharma, and then, my lord, two duplicate copies of loan sanction of National Bank of Agriculture and Rural Development. Then charge sheet, then brief of the case, my lord. Page 25, my lord.
So you could not be located.
That is, my lord, the
We have to go through the scan copy of the case record.
My lord, page 25 for a moment, my lord, charge. Merit, my lord. During investigation, previous visited the PO, drew sketch map of PO, and examined witnesses and complainant and recorded their statement under section 161 CRPC. The FIR named accused Sri Kuldeep Boisho has been proven guilty from the statement of witnesses, complainant, and bank transaction statement. But other two FIR noted persons found innocent. Kuldeep Boisho has been absconding, and we had tried several times to catch him, but I could not.
But the court has taken cognizance.
Cognizance, my lord. So my case is, my lord, from the charge sheet also, it is not a case.
Charge sheet, we do not
Yes, my lord. But in the
give such importance to charge sheet and the views and opinion of the IO.
My lordship.
But privacy, having read the FIR,
Only
some element is there. We have to examine.
My lordship. Only I am relying on a Supreme Court judgment, my lord. If my lordship permits me.
At this stage, we don't think. There are thousands of Supreme Court cases.
My lordship.
On 420.
Only, my lord.
But so far as going through the FIR, it is not that it is an absolutely impossible situation.
Not a case of, my lord, 468 apparently.
No, that I am not saying.
420, my lord.
420, we have to examine that.
I induced him to deliver property to me, my lord.
What is your explanation about the money deposited by him?
One, my lord, the
so far
this
on reading of the FIR,
my lord.
See, it is not only induced, it is by deception also.
My lord, but this deception, my lord, the two loan.
No, deception includes deceive.
My lord.
It is not that
if
induced.
If the allegation
had been forced, many words are there.
But at the very inception.
But if it is deceived that 1,34,000 in your bank.
Two loan sanction amount, my lord, that was seized.
Are you really a man from NABARD?
Yes, my lord.
Are you man from NABARD?
He was, that is, my lord, he has stated.
No. You say you are a man from NABARD.
Yes, my lord. He was an employee and he was, my lord.
He was an employee of NABARD.
Yes, my lord. FIR he stated, my lord.
No. You are the person, Kuldeep Boisho. Are you not Kuldeep Boisho?
I am Kuldeep Boisho.
Have you stated you are a man from NABARD? NABARD or NABARD?
NABARD.
NABARD.
Huh?
NABARD. NABARD.
But the search it. National Bank for Agriculture and Rural Development. This is NABARD.
NABARD. It has to be NABARD, madam. He was an
Scan copy will be required, Lord. You will have to
Scan copy will be required. Then after that, your interim prayer will be considered.
Because, my lord, my case is very limited, my lord. My case is that, my lord, from the bare perusal of the FIR charge sheet.
So far, 468 may not be.
If, my lord, it would have been 468, would have been there.
So far,
then,
Mr. Das, so far, case 20 is concerned, FIR.
My lordship.
It is not that case outrightly.
If that order
fall within 420.
If that order would have been forced, my lord, then, my lord, it may make out a case under section 420. But it is not a case, my lord, that because.
Let us have that.
My lordship.
Scan copy of the record.
From the charge sheet I'm submitting, my lord.
Sirs, they don't go by the opinion of the
They have
ISO.
ceased, my lord.
We'll see to that.
And they have not said that because.
No, we'll look into that.
My lordship. So I'm-
We need to look into
only
that.
submitting
If we
because-
go and sail with the IO,
My lordship.
then what, for what purpose we are sitting here? If
FIR
it
also-
it is, his statement is sacrosanct.
No, my lord, FIR, my lord, that is. the-
FIR,
That is,
I have seen elements of
There is.
that is the
415.
first report of the, my lord.
I heard Mr. MK Das, Learned Counsel for the petition. And Ms. A. Begum, Learned Edition Public Prosecutor for the respondent, number
Please, second.
one, State of Assam, post of this petition under 528. 528?
My lord,
528.
5
BNSS is preferred because I don't recall
Very
BNSS
problematic for us also, my lord, nowadays.
seeking quashing and setting aside of an FIR registered as Dhemaji Police Station case number 442/2020 for the offences under sections 419, 420, 468, IPC, and the consequent and the SARSIT submitted SARSIT dated
31/12/2024.
31/12/2024 passed in that connection in corresponding GR case number 1083/2020 as well as order taking cognizance.
My lordship.
As full stop, the petition has also challenged
Dated 21.
an order
Case
dated
26.
20/01/2025 whereby the Court of Learned Additional Chief Judicial Magistrate Dhemaji has taken cognizance and issued process against the petitioner seeking his appearance. Post of issue notice returnable in 4 weeks as Miss Begum 1 steps upon respond number 2 that's complaining. Informant is informant.
My lord.
Okay, by speed post as well as by usual process within 7 working days from today. First up, for consideration of the case project in the petition, command us scanned copies of PR.
Now, my lord, PRC.
Okay,
18 of the
PRC. PR case number
PR case number
18/2025, within bracket, GR case number 1083.
My lordship.
1083, page 22.
1083.
Within 1083/2020. We call for, this is to be by the registry, right?
Lordship.
Okay. First up, okay. 4 weeks now returnable in so and so. That did you. The prayer for interim relief is kept open for consideration after receipt of the scanned copy of the TCR.
My lord.
28
My lord, next date is fixed. 30.
It is up to you. Seek an adjournment.
My lordship. Huh? Lord, I have been shown absconder, my lord. Otherwise.
We can't help it.
28 January.
Right during through the entire course of investigation. According to IO.
I own.
Charge sheet.
That is correct.
I'm not saying that court has declared you, but according to
According to
IO.
charge sheet.
But if you are a man from NABARD,
My lord.
then he could have easily traced you.
Absolutely, man.
I don't think you are a man from NABARD.
I'm not absconding at any point.
But are you a man from NABARD? You are avoiding my answer query.
I'm yes, my lord.
NABARD?
Yes, ma'am.
Where is your statement?
That, huh?
It is not there. Next.
I'll
Next.
take instruction.
Item number
It's not
11.
there.
Yes, sir.
May I please your lordship? 528 application, but in this case, my very limited prayer is my lord.
528.
I think
Two cases are there.
Where is the FIR?
First FIR is at page 10
That is by the petitioner.
by the petitioner.
Huh? Page 10.
Page
Page
10.
10.
Lord.
10. Ikram Ali.
Akram.
Accused person Hitesh Burman, due respect.
Against Hitesh Burman and Suren Burman.
Both name accused person yesterday 47. 47.
It is a case of 2013.
Came to my shop. I think the agent scolded me. I received a shot.
Second is 14, Lord, page number 14, second
Ah.
FIR.
Is this case charge-sheeted?
My lord.
Is this case charge-sheeted?
This case I do not know, but
not.
this case is registered as
Registered is one thing.
registered as Tihu
You have made out a commission of cognizable offense, so it has to be registered, obviously.
Absolutely.
But whether after 2013 it has been charge-sheeted,
Yes.
Consider. that you do not.
The fate of the
Okay.
case I-
Next.
But next FIR at page 14, that FIR were lost by the
Gita
sister of Hitesh Burman and Suren
I
Burman.
am a very poor widowed lady.
Allegation is very serious.
Yes.
Thereafter, my lord,
Charge-sheeted.
in this case,
Charge-sheeted
charge-sheeted, my lord,
when
is charge-sheeted already. The charge-sheet is at page, your lordship,
you
19,
are Ikram Ali, absconder.
page 19. And thereafter, my lord, this case,
But Ikram Ali.
Akram Ali, Farid Ali, and Anwar Ali. Thereafter, my lord, the case has already been, the trial has already been completed and judgment has already been declared. The judgment is at page, your lordship, 23.
Now why you have come?
My lord, I have been shown absconder in that particular, in this case, my lord. So I do not know about the filing of this case because, my lord, after filing my FIR before the police station, as they have already gutted my house of into fire, then I have no source of income. Thereafter, I went to Tamil Nadu, my lord.
Okay.
There,
You be there and we are dismissing it.
My lord,
Heard, Mr. Dear.
My lord.
You be there in Tamil Nadu. No issue.
no,
We are not commenting on it.
my lord,
Absolutely. What is your excuse?
be
That is
very-
the only excuse.
No, my lord, that is not the excuse. That is not the excuse. My lord, page 27 may kindly be seen. What is the result of this case, my lord?
I have seen.
Page 27,
You better read page 28. Para 9.
my lord.
Read.
Now, scrutinizing material on record, it is found that the exhibit 3 Azahar no prosecutors mentioned the name of Akram Ali, who had committed the offense along with some other person. She could not identify the other persons involved in this incident. The witnesses found the prosecutors in semi-naked condition near the bridge. She informed them that she could identify the Akram Ali who had committed the rape on her after taking her force. Otherwise, I would have come against this order.
No, you're most welcome to proceed to the court of sessions, Nalbari.
So I will appear, my lord.
You appear. You appear.
Some protection may be
No,
necessary.
no, absolutely not.
With all respect.
No,
But it is a case of
absolutely not. We are not
2000
giving you any license. I am Ms. A. Begum, Learned Additional Public Prosecutor for the respondent state. Full stop. An FIR was lodged. The first information was lodged by or against the petitioner by the prosecutrix on 5/7/2023 before the officer in charge, Tihu Police Station. Post of the said FIR was registered as Tihu Police Station case number 56/2013 for the offences under sections 458, 323, 427, 366, 376, IPC page 15. First of after investigation, comma, the IO submitted a charge sheet, right, charge sheet number 252/2015 on 31/7/2015, finding a FIR case well established against 3 accused persons, including the petitioner, herein, pursuing the charge sheet, comma, the petitioner was shown as an absconder. Full stop. The other 2 charge sheeted accused persons stood the trial before the Court of Learned Assistant Sessions Judge Nolbari in Sessions case number 90 stroke, Sessions case number 59 stroke 2015. Full stop. During the trial, comma, sorry, full stop, charges were framed against the other 2 charge-sheeted accused persons for the offences under 457, 506, 376, 34 IPC. And after the trial, comma, the trial court recorded a finding that the prosecution could not establish the case against the 2 charge-sheeted accused person, against the 2 accused persons who stood in the trial, comma, beyond all reasonable doubt, and they were acquitted by the trial court by the judgment dated 15/2/2025. First of para. Insofar as the petitioner, who was the absconder, who was absconding during the trial, comma, the prosecutrix deposed regarding his identity, and the same was recorded in paragraph 9 of the judgment dated 15/10/2025. Post of para. The petitioner has approached this court by the instant criminal, present criminal petition seeking recall of the non-bailable warrant of arrest
PNS.
issued against him, as well as issuance of proclamation and attachment directed by the learned trial court during the course of the proceedings of Sessions case number so and so. First of para. The petitioner has sought to explain his absence during the trial by stating that after the FIR lodged on 5/7/2017, after 2 FIRs lodged on 5/7/2013, there's one by him and other by the prosecutrix, comma, the petitioner went to Chennai in search of job, and he did not return to his native village for years together. Oh, no. I don't know.
I have
I'm stating that after lodging an affair by him on 5/7/2013,
13.
he went to Chennai in search of job, and he did not return to his native village for years together. First off, the petitioner has stated that he had no knowledge about the filing of the affair on 5/7/2013 by the prosecutrix. First off, it is only recently the petitioner came to his native village and has come to learn about issuance of NBW and PNA against him. First off, the explanation provided by the petitioner is found unsatisfactory for recall of the NBW as well as the order for an issuance of proclamation and attachment against him. First of the petitioner for about 10 years. Petitioner did not appear in the trial for about 10 years. It is only after acquittal of the other two charge-sheeted accused persons, the petitioner has approached this court by the instant petition seeking the above relief. First of in the fact situation obtained in the case, commander relief sought for cannot be permitted. The criminal petition is dismissed.
My lord, some observation may have raised some observation that he may
petitioner-
appear before the trial.
First of the petition is however at liberty to approach the trial court. Trial court to stand in the trial.
Obliging.
Item number 12.
Yes.
My pleader lordship. Lordship, this is an application under 528 for quashing of the order passed by the Special Judge Poksho, Morigao.
Special Judge Poksho.
Lordship.
Okay, which will
Here I have to seek some instructions, my lord.
sorry, here 89. Prayer for suspension of sentence.
My lord,
One
my
minute,
lord-
1 minute, 1 minute. Hmm. 50,000.
50,000 already deposited. My lord, 9/12 was fixed for hearing of the appeal before the learned appellate court. My
A
lord.
petition is hereby directed to furnish the certified copy of that order that would be passed by the learned trial court below after his depositing rupees 50,000 before the court below.
My lord, that I could not file, my lord. I have asked to send the copy, my lord, but that is
It is against what?
My lord, what happened?
This criminal petition is against what?
My lord, the petitioner is convicted.
Appellate court said direction for 20%.
20%.
You approach this court against that order.
Yes.
Okay.
Appellate court directed me to deposit 20%. I have filed a petition for waiver of that amount, my lord. That petition was rejected. I have approached this honorable court. This honorable court is the state subject to deposit of rupees 50,000 before the appellate court. I have already deposited, and my lord, 9/12 was the fix for hearing of the appeal, my lord. But
This has to be closed.
my lord,
What is the purpose? Already court has ordered, only thing a formality was required.
yes, then if lordship.
Do you have the copy or not?
My lord, I do not have the order copy of that matter.
Can you get, it is,
It not in the in the e-court services, it is not available, my lord.
did you deposit? Do you have any,
Yes,
by what cash?
No, they have deposited, I'm not sure, my lord, but that is confirmed they have deposited.
Get the instruction,
Yes, my lord.
we'll close it. No point keeping it pending.
Yes, my
The
lord.
appeal will be hard, and this order is saying, say that operation of sentence imposed so and so shall remain suspended till disposal of the present petition.
Yes, ma'am.
We'll dispose it. We'll observe that appellate court, since already an order has been passed to deposit 50,000,
Yes.
which the petitioner has deposited,
Yep.
the appeal should be hard on merit.
Perhaps the appeal, I'm not sure, but perhaps the appeal is already heard, but 9/12 was the date for final hearing of the appeal. But what happened, my lord, the client,
You get the information.
Yes,
No
ma'am.
point keeping it pending.
yes, my lord.
My lord,
Yes, madam.
only one point I beg to submit, my lord. 22 February, in the month of February 24, my lord, that order was passed. And my lord, I am also below poverty line. My father is also, my lord, cancer patient. And
What is the
he-
check amount?
My lord, the 20% order.
What is the check amount?
7,70,000.
And.
Two BPL persons exchanging goods of 7 lakh.
My lord, different amounts were paid, but that amount is.
Both are BPL,
Yes, my lord.
7
yes.
lakh.
My lord, I have given.
Now,
the
have you come across the Supreme Court judgment 269, section Income Tax Act? I'll record that two persons below poverty line, all these are to be reported before the Income Tax Authority. Supreme Court has laid down. Do you have the order? Both are to be reported before the Income Tax Authorities, dealing and exchanging 7 lakhs rupees.
That amount is disputed by me. I have said that.
Whatever. Issuing a 7 lakh check, these are part of the thing, cash. It is to be reported now. 2024 order, you get the order right now at 2 o'clock. This is an order passed in February 2024. This cannot go on, sir.
Lordship may.
At 2 o'clock.
Well, Lordship may take up day after tomorrow. my lord. I
At
will produce the
2
order.
o'clock.
Because this is not available in the website. This is not available in the website also, my lord.
Is he represented by a counsel?
Yes, ma'am.
Was it not their duty
Lord, I have.
from February 2024?
My lord, that.
2 o'clock. I'll dismiss otherwise. It was your duty,
Yes, my lord, that.
February 2024, 1.5 years. That is, we're coming to 2026, 2 years almost. Get the order.
Lordship may take up tomorrow or day after.
Get the
tomorrow.
order, get the order. Make him run.
Item 15.
My lordship. Lordship,
Yes.
it is a case against acquittal under section 138 negotiable instrument act. Lordship, the step has.
When?
Lordship, this is not our matter, Lordship, but one of the junior or some colleagues have informed me that Mr. J does legal aid. He is expired, Lordship.
Huh?
It's
Where is
15.
the order?
Item number 15,
Oh,
Lordship.
2021.
J does is expired, Lordship. 7 November.
JDAS represents whom?
Legal aid, Lordship.
Hey, I say yes. Huh? Repetition. Repetition. And then submitted. JDAS. Office note, await for sole respondent. The respondent is from which place?
It is Boshisto, Lordship.
Bokhisto.
Yes.
RL. Sent by. What is the name?
Syed Matiur Rahman.
We put it before the Lojima court because I think she has been served or he has been served.
Yes.
Maybe
That's it.
there are some
Let us
postal,
start.
some postal papers. But office has said that they have received some letter from postal office. Let them examine. Heard, Mr.
P. Kalita.
P. Kalita, counsel for the applicant. Full stop.
That's it. Matter we take.
Perused the office note dated 6/9/2025. And the contents of and the contents of the letter dated 2/9/2025 of the SPM Beltola SO Guwahati. Full stop. Let the matter be placed before the Lojima court to report as regards service of notice upon the respondent. Full stop. And the office to list the case thereafter. Sorry, for report. And to list the case after 2 weeks with a report of the Lojima.
Item 16.
Yes, Key Mozambique connected the face steps purpose of notice.
I have appeared for
You
that.
have appeared.
Sole respondent.
Sole respondent. 1 minute. Sole respondent.
Yes.
Offense 138.
138.
Is that is not made a party here? Is that is not a party?
Not
Only I am.
good. Okay. Yes.
We have referred this appeal against the judgment and order dated 3/3/25 in criminal appeal number 54/2025.
1 minute. Where is the trial court judgment?
Lordship, operative part is as page
Where is the
69.
trial court judgment?
Yes, Lordship, 69 is the operative part.
Where is the trial court judgment?
It's from page 48, my lord.
48.
Where is the operative part?
Lordship, page number 69.
Yes, then appeal. Appellate court judgment.
Upheld.
Where is that?
73 onwards, my lord.
72. 72 is the order.
Okay. 2020. So direction to pay 9,50,000 remains.
50,000. Lordship, my humble one line I need to say, sir. Lordship, when the check was deposited for encashment, the loan was not matured because the respondent has given.
What loan? I don't know. You tried to take me to the operative part only. But I insisted for first page. Now what is the case?
case was lordship, we have taken.
Let us see the case presented.
Lordship,
Accused an employee, accused. You are employee of ACB. ACB, correct? Resident of colony, use known to the complaining, use financial help. Initially, complainant is reluctant to pay the same amount, but when the accused is repeatedly request, then along with his friend. Or get paid a sound of rupees on different dates, paid to pay the same amount. Issued a check. So where is your defense regarding premature? Where is your defense?
my defense is that.
Where is your defense? Where is your defense? That you are submitting right now. Some premature something. Where is that?
Lordship, it has been in the reflected in the statements only.
Huh?
It was not taken at that time. Now I am.
Yes.
20%. 20%.
Subject to payment of 20%.
Suspension of sentence or
No,
subject
my
to-
lord, they have not in fact sought for suspension of sentence.
No.
Only see the interim prayer, my lord, in the present revision application. Lord,
Oh, I don't know. The order recorded, previous order recorded that after appearance of the sole respondent, prayer for interim order shall be considered.
Yes.
That is why.
Interim prayer may be seen now
Where
at
is the
page
petition?
18.
Where is the criminal petition? Revision.
Page 18, my lord.
Call for the. Huh?
Yes, this is their interim prayer, my lord. They have not
We
sought
cannot
any
grant-
bail, nothing.
What you have not asked for.
Given some time, sir, I'll.
It is up to you.
Additional.
It is up to you. We adjourn then. We are not deciding the revision today.
Yes, my lord.
Right. We have to call for the TCR or what? TCR have to be called for.
Yes, yes.
All right, Mr.
T. Mujumdar.
T. Mazumdar, learned counsel for the petitioner, Mr.
B. Bora.
B. Bora, learned counsel for the respondent. Full stop. As full stop. Full stop. Mr. And Mr. B. Bora, learned counsel, who has submitted that he has entered appearance on behalf of the sole respondent. Full stop. Call for the case records of CR case number 5274 stroke 2018 and criminal appeal number 54 stroke 2024. Postal. There is no prayer for suspension of the execution of the sentence in the criminal revision petition. Postal. Mr. Mazumdar, learned counsel for the petition, has sought listing of the case after 4 weeks in order to file appropriate pleadings. Postal. Be that as it may, list the case after 4 years, 4 weeks for the TCRs.
Obliged.
Item 17.
This petition is filed for quashing the FIR registered at the instance of the respondent number 2, complainant.
Complaint has entered appearance or what?
Yes, Lordship.
Huh? Yes, Mr. R. Dev. For setting aside All Women Police Station 69. Yes, quest diary.
Charge has been filed, Lordship.
Huh?
Charge has been filed.
Charge has been submitted.
On 34.
You have to bring it up.
20.
Heard Mr. S. Biswas, Learned Counsel for the petitioner, and Ms. A. Begum, Learned Traditional Public Prosecutor for the respondent number 1, State of Assam, post of Mr. Rajiv Dev. R. Dev, Learned Counsel has submitted that he has entered appearance on behalf of the respondent number 2, post of. Does command the service of notice upon the respondents is complete, post of. Mr. Dev has further submitted that after completion of investigation in connection with All Women Police Station case number 22/2025, the IO has already submitted a charge sheet against the petitioner.
Charge number.
By charge sheet number,
Case number 23/2025, dated 30/4/2025.
Mr. Biswas, Learned Counsel for the petition, has sought listing of the case after 2 weeks in order to complete his instructions. List the case accordingly after 2 weeks.
Item 18.
Made
18.
This matter actually wrongly listed in admission column matter. Notice of motion.
Ah. Same story.
But-
After acquittal of other accused persons. Huh?
Yes,
In
sir.
this case, I did not receive any summon because for the relevant time, my lord.
No, where is the PNA order?
A PNA order is at my lord page 42.
And first NVWA?
Pass NWA is at my lord 30.
Annexa 4 is there. ma'am.
Hmm? CRPC.
Page 32, my lord.
Huh? 1 minute.
Page 32, the first order dated
Just a
20.
minute, just a minute.
Page 32, NBW or that.
No, not as very fine. I- 40. The same.
Yes, first order
My first order,
for NVWA.
page 33.
Page
33.
30.
Three.
33.
32 is the order. Warrant of arrest
33.
was on 13/6, NBW was first.
Return report seen. You're Soron.
Soron Bosumare.
Come to 32.
32, yes, ma'am.
Order dated 26/4/2018.
Yes, first warrant of arrest was issued against me.
No, read.
Madam. Accused Hitesh Bosumare, Atul Bosumare, Ganesh Narjari, Mongol Brahmo, Atul Ramsari are present. Remaining accused person Soron Bosumare is absent without stake. Common issued to the accused return after service with report.
This is an order recorded by Chief Judicial
By-
Magistrate. So natural consequence is warrant of arrest.
Yes.
Right?
Yes.
So there is no infirmity with the order.
So far.
We have to believe
Yes.
unless you rebut.
Yes. Lord.
Right?
Yes.
Then when this
Subsequently, NBW.
NBW started,
My lord.
NBW started then and there
Yeah,
from
yeah.
26/4/2018.
No, madam. 26 for warrant of arrest.
Huh?
Bailable warrant.
No, warrant of arrest.
Warrant of arrest.
Non-bailable warrant of arrest.
Next, madam, 13/6 NBWA along with proclamation.
Now let us see. When, okay. Warrant of arrest returned with report.
Madam.
Seen. Right. Then issue NBWA along with PNA. When PNA? Section 82.
82, madam. 82. 82.
So 82 appears to be proper.
I am relying on my scope for the procedural parties concerned. My submission before actually such that after the incident, my lord, the political rivalry, the incident was taken place, my lord.
No, we are into PNA and NBW, whether the learned trial court was
committed in-
correct or not.
Yes, that has to be looked into. In this regard,
We are not into political rivalry, sir.
no, my submission before also.
Whether it was correct or because the scope is very limited for this court,
Yes.
right? We somehow try to
Yes.
exercise some power,
Yes.
but if the procedurally it is correct,
Yes.
then our hands are tied.
Yes. I could understand, man. But because so far my client's statement, he stated that he did never receive any summon from any.
That is a different issue. He is.
Guadin.
So which one we believe?
Yes.
The order passed by the Chief Judicial Magistrate,
After seeing the report.
seeing the report, he is not, he's saying that he has seen the report. Someone issued to the accused returned after service with report, which is seen. This is to be disbelieved.
So far that part is concerned, record may also call for, because I am relying on some other statement recorded during the course of trial.
Lordship may also peruse page 43, madam.
We have not, yes, page 43.
Lordship.
Hmm.
It's a details order.
I had to put the order. 82 only option here.
There is nothing to interfere.
Yes.
Otherwise, my lord,
Otherwise if I have to pass an order on these orders, then your thing will be
only
more
one,
complicated.
but before my lord, disposing it, my lord, if you lordship take note of the evidence of PW1, my lord,
Huh?
because statement of the
Oh,
information.
we are not into merit, sir.
That's so.
We cannot, we are in
Yes, yes,
482, we are not appreciating any evidence.
Yes, yes.
No.
Don't misunderstand. We are into proclamation and attachment as well as NBWA. We are not sitting in appeal.
I will surrender that.
So if I
Yes,
observe, better not to,
Yes, yes, I will surrender that.
you better surrender
Uh,
without any order from this court.
Definitely considered in accordance with law.
Huh?
Observation that in accordance.
We'll
with
not
law.
go into merit then.
No.
I will surrender, my lord.
Okay.
Lana trial court will decide in accordance with law.
Okay. Heard
Open to this.
Mr. M.K. Sharma, learned counsel for the petitioner, and Mr. M.P. Goswami, learned additional public prosecutor for the respondent state closed up. After hearing the learned counsel for the parties at some length, Mr. Sharma, learned counsel for the petitioner has submitted that the petitioner would like to submit to the jurisdiction of the land trial court by appearing before it and would prefer an application seeking his release on bail. Post up. Mr. Goswami, learned additional public prosecutor has submitted that if the petitioner appears before the land trial court and submits an application for his release on bail, the same should be considered on merits. Full stop. As the petitioner has submitted that he would submit to the jurisdiction of the trial court and would submit an application seeking his release on bail, and this criminal petition is closed with the observation that in the event the petitioner appears before the submits to the jurisdiction of the trial court and files an application seeking his release on bail, the learned trial court shall consider such application in accordance with law and as per its own merits.
In item 17, my lord. So I was engaged as a legal aid counsel, my lord. Our who is respondent is represented by some other advocate also.
Okay.
So my name may not be.
Miss
any-
M. Bormon, who was earlier appointed as legal counsel, has submitted that her name may be deleted and not reflected in the cause list as the learned counsel, as the respondent number 2 has entered appearance through his or her engaged counsel, Mr. R. Dev.
Milords, may I mention item 20, Milords? Milords, the counsel for the petitioner, Milord, senior counsel, Milords, he requested me for a adjournment. He has some personal difficulty.
My lord, there were certain unforeseen medical circumstances of Mr. Senior Advocate Mr. Kamal Agarwal, because of which he was here only. He had to leave, my lord.
Oh, yes.
Milords, can it be put for 27th of January, Milords? That's a humble request, Milords.
Okay. You are Mr.
Vikas Gupta, Milords.
Okay. Mr. Rathi.
Yes, ma'am.
Mr. D. Rathi, learned counsel for the petitioner, has submitted that Mr. Kia Agarwal,
Yes,
learned senior counsel, who is leading him in this case, has to leave the court due to sudden emergency. So stuff. He has thus submitted he has thus submitted that the case be listed on another day. So Mr. B. Gupta.
Vikas Gupta. Yes, Milords.
B. Gupta. You were there?
I am there for the state.
Mr. M.P. Goswami, learned additional public prosecutor for the respondent number 1 state, and Mr. V. Gupta, learned counsel for the respondent number 2 are present. And in view of the grounds cited for adjournment, They have submitted that they have no objection to the prayer for adjournment, post of as sought for by the learned counsel for the petition and as agreed to by the learned counsel for the respondents, list the case on 27/1/2026.
I'm highly grateful, my lord.
Much obliged.
I think item 14. I'm sorry, my lord, I could not get the order copy, my lord, but I have the instruction that he has deposited rupees 50,000 in cash, my lord, on 6/3/2020.
Okay, Thursday then,
My lord,
Thursday.
on Thursday, my lord.
Okay, Mr. A.K. Gupta, learned counsel for the petitioner has submitted that he will make endeavor to produce a copy of the order passed by the learned appellate court regarding deposit of 50,000 on Thursday, huh? Miss PB
Bodley.
Module, learned counsel for the, you are for
Respondent number 1, my lord.
one, and MP Goswami, additional public prosecutor for the respondent number 2, state of Assam, are present. Please the case on Thursday.
Item 19.
May it please the lordship.
Hmm.
My lord, this petition is praying for quashing of a proceeding, my lord.
Respondent number 2 has appeared.
Yes.
Or respondent,
Yes.
sole respondent.
Yes, my lord.
Yes, my lord.
Hmm.
I'm
Yes.
appearing for the respondent. We are yet to receive the copy of the petition.
Furnish. Then we can take up copy of the complaint. What is this? Setting aside quashing of CNC presently pending before and the order of Swens. Upon a complaint lodged by Swens as a petition to a final report. What was the case?
My lord, case is the petitioner, my lord, sold a possessory
okay.
right of a particular plot of land to the respondent, my lord. So
Okay.
matter is actually, my contention is that it is a matter of civil dispute, my lord. And the respondent lodged an FIR, my lord. A final report has been submitted stating that it is a matter of civil dispute, my lord.
Mr. D.P. Bora, learned counsel for the petitioners is present. Miss
P. Sharma.
P. Sharma, learned counsel has submitted that she has entered appearance on behalf of the sole respondent. Full stop. Ms. Sharma has submitted that a copy of the criminal petition along with annexure has not yet been served upon the sole respondent. Post of Mr. Bora, learned counsel for the petition, shall furnish a copy of the criminal petition along with annexure to so and so by Thursday.
Yes, madam.
Place the case on so and so after vacation. Get it 21st January. And interim order past year shall continue till the next term.
Obliged.
Obliged.
Item 22 for orders.
Lordship.
Yes.
Lordship. Interlocutory application
Interlocutory application.
for consideration, Lordship.
State council has been taken from the appellant to make a prayer. Who are the parties here?
Lordship.
You are for the applicant appellant.
Lordship.
And then respondents 1, public prosecutor. Respondent number 2, you were there.
Yes, Lord.
Yes. Is there anything, this is conviction there?
Section
POCTO.
4, POCTO, Lord.
10 years.
Is there, Lord.
10 years. Is there any provision for filing objection? We are in December.
Lordship, immediately after vacation, Lordship.
LCR come. LCR come.
LCR come, my lord.
Huh?
LCR come.
Lordship, it may be 5th and 6th of January.
No, after vacation.
After
Be after view vacation. 21st or 27th. 27th is Thursday. 28th. 21 or 28?
Yes.
Okay. Last opportunity. Mr. L.R. Mazumdar, learning counsel for the applicant appellant. And Mr.
B. Sharma.
B. Sharma, learned additional public prosecutor for the opposite party, that's respondent number 1, state of Assam are present. Post of Mr. A. Mena, learned amicus query appearing for the opposite party, the suspect number 2 has sought for and is granted further 3 weeks time to submit as a last opportunity to submit to file objection to the application seeking suspension of execution of sentence. First of, release the case on 21st.
23.
Yes. Why it has come?
Office note, my lord, the service of respondent number 2 is awaited.
Okay. Mr. Jiuddin. For the petitioners. B. Sharma. Respondent 1 state also are present. Full stop. Here is the office note dated 25/7, oh sorry, not 25/7, 3/12/2025. Wherein it is reported that service report in respect of respondent number 2 has not yet been received. Full stop. In view of the same, await for the service report in respect of respondent number 2, release the case on a date in the 4th week of January.
Because my
No, all are vacations.
proceeding is going on before the learned court below, my lord. The evidence
20,
is- And my lord, the
28, 28.
record has not been called it to call the record of the case, my lord, because only notice was issued. And it's a charge sheeted case.
What is the case about?
Is it charge sheeted case, my lord, we have challenged the passing of the proceeding of PRC case number 402 of 2019, pending in the court of my lord Norwell. So record is necessary, my lord. I have taken some law point, my lord.
A law point is 156(3), 154(1)(3).
Yes.
Then
Then
allegation in the FIR does not attract any criminal offense.
Yes, my lord.
And that is to be, FIR is to be read.
Yes.
Or permanent receiver of approaches that 2 petition number 2 are
And
teacher,
another-
assistant, police.
So for the dispute regarding who is.
No, you raised 3 points.
Yes, lord.
One is 156(3).
See, my lord, that
Right?
has not been followed, my lord. Yes.
Right.
Yes.
Second is, on a reading of the FIR, no criminal case is made out.
Yes, my lord.
Right?
Yes.
Third,
My lord, so far the issue of.
regarding proper investigation, declared them as absconder.
Subsequently, they appeared, my lord, they are facing trial, man.
So third point is not
Not.
1 and 2.
Yes.
Law point.
No problem.
Reading of the FIR, whether case is made out or not.
My lord, first point is, my lord, the 156 is apparently not followed, my lord. Because
That can be looked into from the petition itself.
lordship.
You relied upon Priyanka Srivastava.
Yes, my lord.
That is all.
Yes, my lord. And our high court also, my lord. And my lord.
Same, not required, as on date. As on date, not required. Why that exercise? Unnecessary exercise.
Lordship.
Scan copy. If you are on, depending on 156p, that can be on the reading of the orders.
My lord, proceeding has not been stayed. That's why my.
The coordinate bench has not stayed. How can I stay now?
But respondent also not appearing, my lord. That's why my.
That service is
Service
complete.
everything.
When Korean bench has applied the mine and has not made any interim order, how can?
Supposed
See
to,
the
my
body.
appearance of the. my lord,
27-1. 28. Wait for response. Nothing has been observed. Nothing has been observed. Nothing has been observed. How can I? Next.
Item 24.
Criminal appeal jails.
May I please
Yes,
continue? As per Lordship, as per office note dated to 2nd of August 2025, service report
Upon respondent number 2 against notice issue on 7th of December 2024 with a signature of Junu. Service is completed upon respondent number 2, Lordship.
448, 354B. Yes, Mr. Sharma, service is complete, perhaps.
Yes. Hearing that maybe.
Junu Bormon. LCA has come.
No, my lord.
Huh? LCA perhaps? LCA has it, TCA?
I say, oh, yet not reflected. 24. Oh, it is, oh, yes, yes.
And any I actually come? I. Yes. Yes, what do you say? Yes, Mr. Sharma. There is a conviction.
My lord.
There is a prayer for suspension of sentence.
Respondent number 2, my lord, service not appeared today.
Service complete.
My lord.
7/12/2024. In December 2024 itself. As per the OCS report, signature is there, Junu Bormon. Yes, madam.
I is not reflected on the cause list.
So you want time
Yes,
to make submission. Okay, Miss
And Hassan.
and Hassan, learned counsel for the appellant. And Mr. B. Sharma, learned additional public prosecutor for the respondent number 1, State of Assam, are present. Full stop. Service report. As regards service of a report as regards service of notice from the in-charge from our wrong side outpost police station, Lakhipur police station, district Valpar, has been received wherein it is reported that the respondent number 2 has been served with a notice. Post up. None has appeared to represent the respondent number 2 till date. Full stop. Yes, POXO case. What to do?
My lord, otherwise amicus curiae may be appointed, my lord.
You know, division, no?
Or legal aid counsel.
No, notification. Sorry, যখন আসছে যা। In view of non-appearance of the respondent number 2 through any learned engaged counsel, comma, you are also legal aid counsel.
Yes, Lordship.
Okay, learn legal aid counsel করে দিব। Okay, Miss Ujjwal Chaudhary, learned counsel from the panel of legal counsel, is to be engaged to represent the case of the respondent number 2. Full stop. Para office raised the case on 23/01/2026 along with the interlocutory application for suspension of sentence.
Applies lots.
Item 25.
Mr. Benedict, I for the respondent the hearing leads the matter up to the petition. What is this criminal appeal?
Yes, Lordship.
Why it has come?
Arising out of maintenance of revisional order.
No, why it has come today in the orders column?
Because admission was.
It has already been admitted.
Yes, already admitted.
TCR has been received.
No receipt.
Huh?
Not received.
Not received.
Right.
Not received.
Not received. Criminal appeal. How it is criminal appeal? Initially, what happened?
A maintenance order was passed by the trial court. Later on, a revisional petition was filed before the session judge. And in that, no relief was granted in favor of the appellant. So before the honorable court.
Who are the parties?
Husband and wife.
Abhijit Ganguly.
Abhijit Ganguly.
Parties. Who filed a petition?
Abhijit Ganguly, Lords.
Before the trial court?
Before the trial court was filed by the wife. It is 125 petition.
125?
Yes.
125 before which court?
JMFC Bongaigaon.
Bongaigaon. Then revision.
Yes.
Under what provision this is appeal?
For setting aside the order.
Oh, no, first is 125 application.
Yes.
Against the order passed by the trial court, you file a revision.
Revision was filed. Yes, Lord.
Then how it is appeal?
Criminal petition, no?
You file an appeal.
Yes, yeah. Here I.
Under what? What provision? Mr. Sharma, I am a bit confused.
Yes, my lord, whether my lord, revision, that revision petition is my lord.
After revision, whether any appeal lies.
Yes.
Understand?
Yes.
Trial court.
My lord.
Then one appeal.
One appeal.
Thereafter revision.
Revision.
It is not that trial court, that revision, thereafter appeal. I have not heard of.
Yes, my lord.
Yes, please explain.
Are any order, my lord, of that revision?
What 5423?
It should be criminal
BNSS.
petition.
You please apply this
Five-
code.
523 was the option only before my lord.
Huh?
For setting aside the order.
No, it has been registered as criminal appeal. Please explain me. You said an appeal under section 423. See, there are differences. Appeal means it is continuation of the original proceeding, and the appellate court has full power to reappraise the evidence.
Yes, Lord.
But after once revision has been preferred, how can it be appeal? Petition for appeal. Something wrong. Inherently wrong. 442. New BNSS. Yes, revision. Second revision. 528. You have invoked everything. Huh? Inherent power, revision power, appellate power, mixed everything, file a petition.
Under the revisional power and before the honorable.
And why you have preferred it as a appeal? Make some homework. Otherwise, second revision is barred. Is it not?
Yes, Lord.
You should have filed it only under 482, means 528.
520, inherent power. Criminal petition.
You are rewriting CRPC. What is it? কিহৰ কাৰণে আহিছিল? আহিছে কিহৰ কাৰণে? TCR কাৰণে নেকি? এইটো কি? Appellant is not RB for present adjournment. Appeal is admitted for hearing. Mr.
ML Pandya, Lord.
Pandya, petitioner. B. Sharma. 1. Respondent number 1 state. RB Bora, learned legal aid counsel for the respondent number 2 are present. So, the petition has already been admitted for hearing on 17/9/2025. Let TCS be called for. This is the case after 4 weeks.
It's after vacation.
Item 26.
My lord, my तेरे office no dated 10/12/25.
Not sir, return.
My lord.
No, perhaps, my lord, in this case, my lord, it is not through proper channel, my lord. So it should be, my lord, through our PP office. The register.
3 steps.
My lord.
POXO.
POXO.
Heard Mr. P.J. Sohia, learned counsel for the appellant, and Mr. B. Sharma, learned additional public prosecutor for the respondent number 1, state of Assam. Post of. As the conviction of the appellant is under Section 8 POXO Act, let notices be served upon the respondent number 2 through the jurisdictional officer in charge, that is Morigaon Police Station. Post of the notice is to be served through the learned counsel for the appellant shall serve requisite notice at the office of the learned public prosecutor, Guwahati High Court. Guwahati High Court.
My lord.
Okay, within 7 days from today. And public prosecutor shall cause serving of notice upon the respondent number 2 to the officer in charge, Morigaon Police Station, and thereafter to obtain a report as legal service. Post of. Release the case after 4 weeks.
Item 27.
May I please, Lordship? Scan copies of TCR received, Lordship.
On periodic appeal has been received by the brother. What is the conviction?
2 years rigorous imprisonment.
Under section.
498A.
Okay. Mr. Sharma, none has appeared.
Yes, my lord.
Not required. 498.
My lord.
Not required to appoint any legal counsel.
My
Legal
lord.
counsel.
But my lord, petitioner now
It's an
respondent
appeal.
to-
Where is the judgment?
Lordship, page number 10.
Page number 10. This is subdivisional judicial magistrates. Then they have to appeal.
Yes, Lordship.
Appeal.
Yes.
Appeal on
Conviction upheld.
Yes, Lordship.
Conviction upheld.
Yes, Lordship.
It-
Later on, they compromised.
This is
concurrent finding.
after conviction, what compromise? This is criminal petition.
Yes, Lordship.
On the ground of compromise.
Yes, Lordship.
If you see, if the revision is dismissed on merit,
Yes.
then presence of respondent number 2 is not necessary. But if you want to press the point on compromise,
Yes, sir.
then her presence would be necessary.
Lordship, we tried to contact her, but she
That
refused.
she was your wife. We don't know.
She refused to come, Lordship.
Then how compromise?
She is asking for more money, Lordship. I have already paid the
Then merit
compromise amount.
service report in respect and received back from
Notice
the
is come,
center in the respect of his report received by someone, Nazim Ali,
Yes, Lordship.
by putting
Brother
signature.
of
Hence,
respondent.
either ID card, however. Her Miss
K. Borman.
K. Burman, learned counsel for the petition, and Mr. B. Sharma, learned additional public prosecutor for the respondent number 1, State of Assam. Let the case be placed before a law Jima court to ascertain service of notice upon the respondent number 2. Which was sent by registered post. Post of. Release the case after 4 weeks for report of the law Jima court.
I know.
Item 28.
May I please, your lordship? My lord, in this case, my lord, there is an order dated 4/8/2025. My lord,
4/8.
2025, para 8, my lord. Then, my lord,
4/8.
interim prayer will be, my lord, considered after the receiving of the TCR, my lord.
Due to paucity of time upon instruction, none appears to represent Oruna Pupan is appointed.
Already, my lord, amicus.
But his name is not reflected.
Yes, my lord.
Ah.
Last occasion also I prayed before.
No, how can we know? Because how can he know if his name is not reflected?
Because my lord, last occasion, my lord, I prayed before this honorable court that his name should be shown, but there is an
Not
order.
shown.
But there is an order, but has not been shown. So, my lord,
Mr.
S.A. Shikdar, my lord.
S.A. Sigdar.
Kindly
For the
date-
petitioner.
give a date before vacation, my lord. Because, my lord, he is inside since 16/6.
Okay.
My
No, you argue then.
My lord.
If you want
My lord.
your case to be argued, if you insist, we'll go.
My lord.
What is your conviction? 376/511. Yes, ready.
My lord, I'm not today.
My lord,
It will go after vacation, mister.
নেমটো show কৰিব দিয়া নহলে
POCSO case.
POCSO case টো শুনি
5 years was convicted.
376. 110. Mr. B. Sharma, additional public prosecutor for the respondent number 1 from a state of Assam. By an order dated 27/11/2025, Mr. Oruna Phukon has been appointed as amicus curiae to represent the respondent number 2. Full stop. However, the name of Mr. Oruna Phukon and amicus curiae is not reflected in the court list. Full stop. Release the case on after PU 21/1/2026, reflecting the name of Mr. Aruna Phukon, learned amicus query for the respondent number 2 in the cause list.
Kindly make short date, my lord, on January first week, my lord, kindly.
No, there are hardly 5 days. Already cases are fixed.
Hello, list.
29.
May I please, your
In
lordship?
this criminal petition final order, yes, service.
Service was not completed, my lord. We have taken step as the. by a-
Letter cannot be
Legal process.
22/7. Cannot be delivered to how many respondent?
One respondent. One respondent. There is Elias, therefore, my lord.
Huh?
There is Elias, my lord. Details of Elias. Elias.
Himasri Pathak, Jasmina Bengal, so many names.
Lordship. Therefore.
Huh? This is very illegible office note.
Lordship.
Unserved registered notice in respect of sole respondent has been received back with postal remark. A letter cannot be delivered to, therefore return to sender. Has returned.
We
You
have
take
take-
first steps.
We have taken the usual process also. That report was not come. That is.
You have to wait then.
Lordship. Lordship.
Heard
Is there
Mr.
maybe call for home?
H.A. Ahmed, Learned Counsel for the petitioner. Full stop. Peruse the office note dated 11/12/2025. Full stop. Raised to call for a report as regards service of notice upon the sole respondent, which was sent through the district magistrate Borpeta. Release the case after 4 weeks for service report.
PCR may be called for. PCR earlier not possible.
It's a notice. Let TCR be called for.
Item 30.
It is already admitted and LCR call for is also received. But notice upon the respondent of 2 has not been served, my lord.
Actually not served because no step was taken.
But she inadvertently a step was not taken, so we make it directed to take first step.
Mr. K. Sharma, Learned Counsel for the appellants, and Mr. B. Sharma, Learned Additional Public Prosecutor for the respondent number 1, State of Assam are present. Mr. Sharma has submitted that inadvertently, step could not be taken upon the response for service of notice upon the respondent number 2 post of. He has prayed for a week's time to take first steps for service of notice upon the respondent number 2. In deference to the order dated 7/8/2025 through both the modes, post of the prayer is allowed. List the case of the 4 weeks for service report in respect of respondent number 2. Both modes.
Item 31.
Mainly appeal. LCIC. LCIC.
Sir.
304. There is no representation on behalf of the appellant today on call. Mr. B. Sharma, Learned Additional Public Prosecutor for the respondent. State is present. First of, as the TCR has been received, Sharma lays the case in the for hearing.
Ma-
Already admitted.
All.
Item 32.
May I please, Your Lordship? Appeal minor under section 10 of POSCO Act, my lord. We have taken the step, my lord.
What happened?
Step, my lord.
Notice issued.
Notice issued, my lord.
Notice issued.
Await for service.
Await. Mr. S.K. Joint Learned Counsel for the appellant and Mr. B. Sharma, Learned Additional Public Prosecutor for the respondent number 1, State of Assam are present. Peruse the office note dated 29/10/2025. Post of. Await for the service report in respect of respondent number 2. Leaves the case on a date after 3.
TCR may kindly call.
Huh? TCR not call?
Not call for.
Okay, the TCR we call for. Huh?
Oblige, my lord.
Leaves the case after 4 weeks.
Oblige.
For service report and receipt of TCR.
LC. TCR. Oblige.
Item 34.
Yes.
I filed for suspension of sentence in connection with criminal appeal.
My lord, here I have a prayer, my lord. A 10 years conviction, so I may be allowed to file objection.
So here this section
Under
37 again comes.
37 again
comes. Opportunity should be given. Okay, I order person. Heard Mr.
M. Pathak.
M. Pathak, Learned Counsel for the applicant appellant. And Mr. M.P. Goswami, Learned Additional Public Prosecutor for the opposite party, that's respondent number 1, State. Or respondent state.
State. Sole respondent.
This is an application under section 430. Bharatiya Nagorik Surakha Samhita 2026. Seeking suspension of execution of the sentence passed against the applicant appellant. First of all, the Learned Special Court has convicted the applicant appellant for the offense under section 20 within bracket small b within bracket small Roman 2 within bracket capital C and section 29 of the NDPS Act, and he has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 1 lakh.
1 lakh.
Come out with default stipulation. First of all, Mr. Goswami has sought for and is granted 4 weeks time to file an objection to the application. First up, granted list the case after 4 weeks.
Lordship,
A TCR has been received.
TCR is available.
TCR is received, my lord.
So paper book may be directed.
Paper book, you pay deposit, we direct only. You deposit. Is there provision?
My lord, normally, my lord.
For single mans, no.
No, my lord.
Automatic paper
Automatic.
book.
No.
So you deposit the cost.
Yes.
We can direct, I think. There is a provision in the Guwahati High Court rules part.
Rules.
Read the provision, come back, deposit the cost, we'll direct.
Item 35.
Where is your friend?
He also, in fact, we were arguing.
He is conspicuously absent. Whatever his approval is required.
Yes. A and no, my lord.
Yes, I know his presence would be required. His presence should be required when? Let us go to the New Year. Mr. R. Dubey, learned counsel for the petition is present. Mr. S. Somoria, learned counsel for the respondent, opposite parties, is found absent today on call. To stop. In view of non-representation, non-appearance of the opposite parties. Is the case again on first week or DG? First week. Hold on.